Hi and welcome. I'm Antigone Peyton with Cloudigy Law. Welcome to our Everyday IP live stream. And today we have a really interesting topic that we want to cover with you as part of our ongoing effort to help you create, grow, and protect your IP. With me today is Amanda, and Amanda is an attorney here at Cloudigy Law. She's an intellectual property attorney, and she is also a gamer. So Amanda and I have had a lot of conversations lately about IP issues involving online worlds, virtual worlds, online gaming, multi-person gaming. So we wanted to share with you some of our nerdy conversations. And today we're just going to be talking about trademark issues, but we're also going to introduce the different types of online games that we're concerned about and how trademarks are used in those games, or things that in the real world could potentially be called trademarks. And we're just going to take it from there. And feel free to ask questions as we start this discussion, because we want this to be interactive. So Amanda, let's start by talking about the types of virtual worlds in the games that you play and other people play. I think that will be helpful for people to understand why we're talking about trademarks and how they're used in these worlds.
Sure. When we're talking about virtual economies and trademarks and things like that, which are necessarily commercial rooted transactions, the thing that immediately comes to mind to me is MMOs and multiplayer games, just because you're having more of an interactive marketplace where commercial transactions could be more relevant. So, not to discount the many single player games and strategy games out there, but they're not really the subject of what we're talking about. What we're really looking at is MMORPGs. Whether they're Sandbox or theme park, they tend to have player driven economies.
So what's the difference between Sandbox and theme park?
Well, a Sandbox RPG is when the developer creates the world and they basically make a world for someone to play in, and the characters can do whatever they want within that world. There's no linear progression, which is what a theme park MMO is. So with theme parks, we're talking about things like World of Warcraft, Wildstar, your very traditional rating and game content focused games. They actually tend to be the ones I play as well. So these are my personal experience. These are ones where the developer creates the world, they create the content, and the players are free to ride whatever rides they wish in that world, but you are riding rides, not destroying things randomly. Sandbox MMOs are different, like I said. They are, and actually you can have sandbox and RPG worlds as well that are single player. They are the developer creates the world, and you can do pretty much whatever you want within that world. You can play in the sandbox as you see fit. We're thinking things like Skyrim from the single player standpoint, or EVE Online from a multiplayer standpoint. Also, Second Life. The developers have maintained that Second Life is more of a platform for other games and content, but they are very, very broadly kind of a sandbox MMO as well.
So I imagine there's a difference in the way that things that are traditionally called trademarks in the real world are used in these worlds. So if I'm in a world where I'm creating real estate, houses, things of that nature, and I'm using things that would normally be called trademarks when I'm building as an architect in these virtual worlds, that could be very different than if a developer creates the virtual world and they're using either traditional trademarks like Starbucks or Tiffany's or things like that to make the world more realistic, versus what I create and potentially sell or license to others.
Yeah, and that's part of it. So when you're talking about developers bringing in real world trademarks like Tiffany's and Starbucks, that is under a kind of fair use ground, where they're saying our game is creative expression, and part of our creative expression is to create an immersive world that kind of mirrors the real one. And there are a lot of cases on that. It's not what we're really talking about here. What we're talking about here is when players, for example, in Second Life, players can create in-game objects. What if a player took a bunch of in-game items and created a Starbucks cup, and they start selling that Starbucks cup to other people in Second Life? That's infringement of Starbucks trademark, and because Second Life has a real cash economy, it could be an instance of actual damages. But also on the flip side, players in the world can actually form their own brands. Like in Wildstar, for example, I bring up Wildstar because I played it quite a lot and I used to rate in it quite seriously. there's a girl named Katia, and she does tours of housing plots, and she builds housing plots, and she has a kind of brand that's associated with an add-on she makes in her Twitch streams, but it's all through her virtual interactions. And so does she have a trademark and Katia, the avatar name, or anything like that that she's using? That's kind of what we're trying to decide.
Yeah, so this is really interesting because one of the requirements for trademark law is that a particular mark is used in commerce, right? There's this magic legal language in commerce for purposes of identifying the source of particular goods and services. So let's explore that a little bit in the different types of worlds we're talking about, some which have real, what I'll call real world extensions or real world values for the things that you do and you create in the world, and the virtual economies versus the ones that don't.
Are you talking about like systems that players can do to create?
Right. So let's say we have a particular game that we're playing where there's real world value for the things that I create, and some of the things I create are creative and original, and they're brands that I create for purposes of interacting with others and obtaining virtual currency. What does that mean?
Well, it depends on the type of game you're playing. For example, in Eve, you have to mine resources and things like that to build your ships. And as part of that system, corporations rise up, and they are basically like giant guilds, but also they have a corporate structure, and the game supports the ability for players to organize in that manner. And people can, farm the resources and then sell that for currency, which other people will then turn into a ship. And that's just a very basic example of how players organize, but things that allow that in various systems, and all games are different about what they allow and how, but games typically have auction houses, player trading, shops and stalls. Sometimes you can just set up a stall somewhere without any NPCs and just sell directly and haggle and whatnot. You can craft things. Different games have different types of crafting professions, farming. There was in Second Life actually a bunch of in-game banks that gave interest-bearing accounts to people that kind of caused a market crash when there was a rush to the bank. They kind of gotten rid of that since then. There's also gold sinks and faucets because they mirror healthy economies, and a lot of player services have kind of come up in recent years, like player marriage and divorce, player architecture. So like Katia, she builds houses and things, but a lot of people use her add-ons to literally sell custom-made furniture, and they advertise on forums and say, hey, my avatar will make this for you for in-game gold.
So I'm going to take my lawyer hat off for a second. When I think about this concept of trademarks and identifying that I'm the source of particular objects that I create in a virtual world, it seems like that concept does relay in the virtual environment. So what do we think from a trademark perspective this means? Do we think that there should be trademarks in virtual worlds that people can create when they can build objects of their own and trade and sell to others through use of virtual currencies and virtual economies?
Well, that's tricky because in almost all types of games, a player can cash into the game. They can use real money to buy in-game time, special items, cosmetic services, premium services. Really depends on the monetization scheme of that individual game. But it's actually relatively rare for players to be able to cash out and directly convert their in-game money into real-world money. That would be games like Second Life, for example, where you can literally exchange your in-game currency for real currency. And the game itself supports that. In most games, it's against the terms and condition to do gold selling, account selling, and things of that nature through third-party websites. So when we're talking about player-made trademarks, my question is always, is the in-game actions enough to count as in commerce as a transaction? And I think it really needs to be tied to real-world money.
So let's talk about that, what that means. Let's say the game itself doesn't actually allow you to cash out, but there's this whole ecosystem of players that have created their own platforms where they're trading and using real world currency in order to barter, things of that nature. What do you do in situations like that? Do you think that that's in-commerce use of trademarks if they're trading objects that might otherwise be subject to trademark protection?
If we're talking about real world items like the Starbucks example I gave earlier.
But an item that you use in a virtual world, right? So if you're trading objects like a real world a Starbucks item in real world cash, on another platform, is that a trademark usage under our traditional trademark law?
Again, I think it has to be really what is the individual game's monetary scheme and how easy is it for players to translate the in-game money into real world value. So like, just to give an example, in Eve, there was this famous headline about a battle that cost $300,000 worth of spaceships. And
An epic battle.
An epic battle that cost $300,000 worth of spaceships because someone forgot to pay their rent. And basically players just over a series of hours destroyed a bunch of in-game assets. And they were able to value that as $300,000 because there's an item in Eve that you can buy with real money that gives you playing time, because Eve is a subscription game, and you can trade the item in game. So players would buy it with real money and trade it to their friends for in-game currency. And so you can say roughly, well, that $15 item is worth this much in in-game currency. And so they use that to value the spaceships that were lost at $300,000. However, it's really somewhat difficult to realize that ascertainable real world value because the game itself doesn't allow you to translate your in-game money back into real world money. So to me, I think whether or not a player transaction should count as a commercial transaction for trademark protection really should depend on how easy it is for players to realize the ascertainable real world value.
Yeah, that's really interesting because it looks like there's a number of hurdles here that a trademark owner or somebody, whether they create the trademark in the real world and it's converted to the virtual world, or if they're the developer or a player in the virtual world creating something that, if it were created in the real world, would be a trademark. There's a number of hurdles that have to be overcome in order for them to get that same type of protection in the virtual world, even though when we think about it in the computer-based sense with these multiplayer games, there's information and about those trademarks in the code that's transferring all over the place, right? So when you are looking at your display of the game that's housed on a server and you're playing with a bunch of different people around the world, when we're talking about trademarks in other contexts like websites, the fact that this information is being transferred over the internet has been enough to call it use in commerce. But we're just talking about a different animal since we're in the virtual world and use of trademarks in the virtual world.
Yeah, and I think that's really the thing is that there haven't really been any real decisions trying to apply it to purely virtual transactions.
Right.
If you look at how people are using it on websites, it's still tied to some sort of real world value. If it's truly a virtual value, how can we say that's a commercial transaction? I don't know. Maybe a court would say it is. Maybe it wasn't. My personal opinion is simply that unless it has a realizable value, it shouldn't be considered commercial. Transaction, yes. Commercial, maybe not. It's not a sale, I guess is what I'm trying to say.
So what does this mean for people who are quite successfully creating original items in virtual worlds? Whether they're in one of what we call these sweatshops, right? Where they're gaining currency and they're creating things, and they're located in certain areas around the world where that's all they do, and then it's converted to real world currency, and that's their job basically, to play the game and create these items. What does it mean for situations like that, and also others who have created some really original stuff and their own brand in a virtual world? Are we just saying, I'm sorry, you just don't have trademark protection?
Well, I think part of it is also that the games all have different terms and conditions. So a lot of developers and publishers write into their terms and conditions that the publisher or the developer owns the assets in the game, no matter how they're used by players.
That's really interesting because if they're assets that you created and you built
with their code, engine.
Yeah. Right. So again, read the terms of service.
However, there's actually a very unusual situation. Second Life actually says that the players own the content they create, including the intellectual property. So if those players wanted to, assert rights over it, they can. And in fact, I think there's even an avatar in Second Life who was kind of famous for being the first Second Life millionaire that copyrighted their avatar, but I'm not positive on that. But it's kind of a very unusual situation. As far as monetizing virtual assets, well, you also have to look at it from the developer's point of view. Like some of these developers have very famous in-game brands that don't exist in the real world.
Right.
What's to stop someone in the real world from just saying, hey, I'm going to produce that in-game soda and sell it without their permission?
Well, so let's talk about a couple examples of that, because I think that's a really interesting question. So famous personalities, for instance, famous avatars, famous products in virtual world. Who says I can't go out and create my own brand line using that avatar likeness or that particular brand?
Well, that brings up fair use as well. But I'm more thinking in line of, can the virtual transaction actually give rise to trademark protections outside of the real world? Say the developer never used it in real world. Like, this is kind of a weird example because they actually did end up making a real life soda for it. But Nuka-Cola, super famous in Fallout. Everyone knows what Nuka-Cola Quantum is if you played Fallout. And in fact, they did actually make a real world soda, Nuka-Cola. But if they had never done that, and the entirety of Nuka-Cola was just in-game transactions, could they have created a real world trademark protection, or would someone like Coca-Cola have been prevented from making a Nuka-Cola product?
Well, it's interesting. So this brings up another question in trademark law. It's infringement when somebody is confused about the origin of a particular product or service. So for this particular cola, if I bought it at a convenience store, would I think that it was created by the person who actually created it in the virtual world or the developer of a particular virtual world? I'm not sure I know the answer to that question because we think about product line extensions all the time. I mean, where can you go now in the United States where you don't see something relating to a Star Wars figure, right? There's a lot of licensing going on in that world, for instance. And so these are all partners that have rights to copyrighted material and trademarked material. I may be a little confused if I see this virtual virtual beverage in the real world. I may think it comes from the developer or another related company.
I would say so, especially since some of them are so famous. But again, they exist only in virtual worlds right now. And it's just very interesting to me how trademark, which is so rooted in commercial transactions, actual sales of goods, could potentially be applied outside that. Like Sprunk soda from Grand Theft Auto. It's a pretty famous soda in the game. It doesn't really exist outside it as far as I know, unlike Pisswasser, which is another Grand Theft Auto drink that actually was made as a promotional product. If someone just started selling lemon lime soda with the Sprunk name on it, I would probably assume it was officially licensed as a product from Grand Theft Auto.
So if you're going to a gamer convention and you saw this beverage, you might think that it's been created by the company or their
Absolutely.
licensee. Yeah.
But again, there's no real world transactions giving rise to that. And the implications for player made content, player made services, not just the developer made ones, are pretty interesting as far as I'm concerned.
So if I'm a developer or a well-known user who's created a famous in-world brand, this conversation is kind of concerning to me because it feels like I've developed something special and I've gained virtual currency value from the thing that I've created, but it may not translate to real world value, and somebody totally unrelated could theoretically come in and create the very same brand in the real world, potentially without consequence.
Yeah, it really just depends on whether or not, if such a case came before the board or the courts, if it was considered a use in commerce in the virtual world.
So just so everybody knows, there has been no court that has decided these philosophical issues that we're talking about, right? Which means that some party or some individual is going to have to ask a court to decide this. But this leads to an issue that we talk about all the time since we deal with a lot of technology law, which is the fact that it's really some of this technology and the way that these systems work are really confusing to judges. And we see this all the time in our IP cases. So sometimes they just don't understand what's going on and what the issues are and why something is such a problem. So to be determined whether a court's going to really understand what's going on here and whether they're going to differentiate between creation of customized brands and well-known or famous brands in a virtual world versus creation of famous brands in a real world, and whether the court's going to recognize the brands in the virtual world.
Yeah, and also just to give some background, part of why we're talking about so much of the e-commerce is that trademarks protections are rooted, constitutionally rooted in the Commerce Clause. And so a lot of it depends on whether or not these type of virtual transactions are considered under the purview of the Commerce Clause. Does the US courts even have authority to regulate this sort of thing? So.
Well, so Amanda, what are our takeaways? We always like to talk about takeaways after we cover a particular topic. What are our takeaways about the things that people create or developers create in the virtual world? Where do we think the world is heading when it comes to dealing with potential trademark issues involving virtual worlds?
I think that it's a little different from developer created content and player created content and services, first of all. And we're talking about the ones created in a virtual world, not applied from the real world to the virtual world.
That's a different
That's
live
a different
stream.
That's a completely different
We're going to cover that in a different live stream.
Yeah. I think that if you're a developer and you have a real cash economy, that's like Second Life, where you can directly exchange in and out currency for real money. It's not just one direction, it's both directions. I think that your content is probably protected as a trademark just because it is a commercial transaction. It can be directly exchanged back into real money.
Or it should be.
Or it should be,
This is for the courts to decide. We're
exactly.
Not judges.
I think that it's also a little bit more protective of developers, especially developers of famous in-game trademarks like Sprunk would be, or Aperture Science would be. For those of you who are nerds like I am, you know what they are. I think that's a little bit more protected just because it is a famous mark. And our intuition is that famous marks should be protected from copiers. But if you are a, small indie company, or you are a player of said games that, you've developed a persona around an avatar and you use that avatar to do in-game services and whatnot, maybe talk through that avatar on forums, I think it's a little less clear, and that if you can tie it to the real world, you should. So if you are an avatar persona, do streams if the game's terms of services allow you to stream their game, make content, do events and shows and things like that. Make add-ons, I don't know, things like that. I think that the more you can tie it to the real world, the safer you are as far as that's concerned, if something you want to protect. And also, it also brings up the question of, again, the Starbucks cup we talked about at the very beginning,
right.
Of if you are a real world brand and you're seeing your product show up in a game that has a real cash economy and you want to stop your trademark from being used in there, maybe think about actual damages instead of just statutory damages. If that in-game currency has an ascertainable real world value that you can actually realize by changing in and out, I think that's another avenue of damages to look at.
Yeah, so we should talk a little bit about that because damages is another hurdle that we have to think about differently when we're talking about virtual worlds and online games. So, and it's a lot like social media where you might question, well, if somebody's working for a company and they create a Twitter handle that's a hybrid of the company name and their own name, and they try to take that handle into hundreds of thousands of followers with them, or tens of thousands of followers, what's the company damage? What's the harm? What's the value of those followers? The same thing with Facebook likes, people following a particular page. Courts and people who are trying to describe the harm there are having a real hard time doing so, because it's not like our traditional damages analysis, right? But it is a lot like virtual worlds, where you have these whole different value ecosystems that often are created on virtual currencies and economies. They involve virtual banks. I mean, they're a lot like real world economies. Sometimes they have people who are manipulating the market to make
Ponzi
sure
schemes.
to make sure the virtual world doesn't crash. Ponzi schemes. For every game, there's somebody who wants to game the system, right? So in a lot of ways, they really mirror the real world when we talk about monetary value in the real world economy. But let's talk a little more about that, because I think that's another interesting issue that, again, courts are going to have to struggle with and figure out, and parties who feel like they're damaged are going to have to struggle with and figure out as they try to create this story about being damaged by something that happens with their brand that they create in the virtual world that goes to the real world.
Yeah, I think tied up in your question is actually just a quick summary of what the different monetization schemes tend to be these days. The most traditional type is a subscription based. That's your World of Warcraft, where you pay $15 a month to play the game. And if you stop paying it, you can't play anymore. These have kind of been altered in recent years with the rise of the free to play game. And so they often have a item you can purchase with real world money that extends your game time that you can trade in the game. So for example, if you have a real job and make enough money that you can spend a little bit on the game, you can buy that item and then sell it to a player in game who's been farming in the game for a long time to get some in-game currency without putting the time into it. And in exchange, that player who farmed a lot doesn't have to spend real world money to get another month of playtime. So that sort of thing is going on in subscription-based games these days. There's also the freemium, free to play, buy to play with a cash shop. There's all sorts of variations on this, but the general idea is that the game itself is free to play on a time basis. You don't pay for monthly time to play it. But there's a cash shop that has extra benefits, extra services, cosmetic items, things of that nature that you can buy with real world money. And so in that sort of way, the whales, that's what we call it, are basically subsidizing free players to play the game. And then you also have the real cash economy, which I mentioned a couple times is like Second Life. That's when you can buy in-game currency with real world money, and then you can later change that in-game currency back into real world money. And there's exchange rates and things of that nature. There's some limitations on when you can do this, but in general, there are players who do make money off of these games and do it. And like I mentioned, there's the avatar in Second Life who's famous for being the first Second Life millionaire because they had enough in-game assets to equal $1 million in real world money.
So let's talk a little more about damages, and I think we need to wrap up because we could go on forever about this topic. It's a really interesting topic, but I will say that we've decided to create a series of live streams on this topic because it is so interesting, and almost all of the really important issues have not been even touched by a court. So when we're trying to help people navigate these issues, it's really important to understand what type of platform it is, how people interact with it, what happens in the game and who does it, what does the developer bring to the table versus the players, and is there a real world cash out for the things that you create in the game? And all of these are really big questions, but when we hear that one of the most important products that was sold during Christmas of this past year was some of these virtual headsets, we know that the world is moving towards more people are going to start using virtual games and playing in virtual games in virtual worlds. So I think that at some point soon, some of these issues are going to start to come to a head, and somebody's going to go to court and ask a court to figure it out. So to be seen what a court does, but I think what we've highlighted here is there is something different about virtual worlds, particularly when you're creating what would otherwise be considered IP assets in real worlds, but you're creating them in the virtual world. There are many of these virtual worlds where you may not have any protection from a trademark perspective for what you create. And even if you do have some protection, it could be fairly limited, right, to that virtual world, and how a court would consider something that happened in the real world, even if you have trademark protection in a virtual world. Well, if somebody creates a similar or the same line of soda in the real world and they sell it at a gaming conference, is that infringement of your trademark? And how is it infringement of your trademark? So there's a lot to figure out here. I think we've done a good job of asking a lot of questions and saying there aren't a lot of answers from a legal perspective. But hopefully we've given you some guidance and help in understanding what's happening in these worlds and how they're different and how trademarks play a part. So thanks for joining me, Amanda. So for our listeners, if you're interested in following up on this and giving us ideas on other topics that we can cover on this type of show or other IP topics in general, please send us an email at info@cloudigylaw.com, or you can find us on Twitter at cloudigylaw.com. Also, remember to check out our Facebook page. Twice a month, we do these live stream shows. And maybe next live stream shows, we'll talk about real world trademarks in virtual worlds, because that is different than what we were talking about today.
And less theoretical. There actually are some cases out there on that.
The courts are starting to deal with that issue, right? Big, well-known brands that are starting to be used in virtual worlds. So stay tuned, and we hope you join us next time.